First of all, I want to thank everybody for joining us this morning in our breakfast briefing on getting the deal done, purchase order pitfalls and protections. I'm confident that within the next hour, this is the hour of presentations, that you'll find something of interest and probably useful down the road, if not today, because this is the kind of day-to-day information that oftentimes some of us are dealing with it, but oftentimes people just don't think about these types of things. My name is Peter Turner. I'm the managing partner at Myers, Roman, Friedberg, and Lewis. All companies buy and sell materials, equipment, or goods of one sort or another, from raw materials to office equipment, depending on what your business may happen to be. And on occasion, something goes wrong, which gives rise to problems ranging from product failure, disruption of business, and even personal injury. Because of the often unusual ways companies exchange offers and counter-offers, frequently with no one ever signing anyone else's document, a set of laws was established which was incorporated into the Uniform Commercial Code, otherwise known as the UCC. And as lawyers, we deal with this all the time. The UCC is now the law in almost every state except Louisiana, which still uses the Napoleonic Code. This set of laws has some very useful but surprising results when applied to the sale of goods. With the advent of electronic communications and the propensity of business people to conclude deals in real time with emails or even instant messaging, a new body of law is emerging that adopts many of the common law principles adopted in the UCC, but with some unusual twists that lead to sometimes surprising outcomes that you'll be hearing about during the presentations. The first presenter is Russell O'Rourke. Russell is a partner. He's chair of our firm's construction law practice group. In Russell's 30 years of practice, he has dealt with many disputes involving UCC issues, and he will be our first speaker. Russell will be followed by Scott Lewis, who is a partner in our firm's business and corporate practice group. Scott is also in his 30th year, if I'm not mistaken. 29th, he's not there yet, of practice. And Scott counsels a variety of clients on business issues on a day-to-day basis, including terms and conditions and commercial dealings. And finally, Ron Friedberg is a partner of the firm. He's the chair of our surety practice group. Ron has 23 years of experience, and he's also an active member in our firm's commercial litigation practice. Ron has addressed, litigated, and tried numerous UCC disputes arising from all kinds of different situations, so he'll have insight to provide as well. And with that, I'll turn it over to Russell.
Thank you, Peter. Kind of surprising. Peter says, hey, you're the old man up here. So 30 years of experience, God, it's almost impossible to believe that's true. What we're going to talk about today, as Peter mentioned, is purchase orders. And purchase orders really, the whole purchase order process. One of the things Peter also mentioned was that companies frequently trade forms back and forth, and no one ever signs anyone else's forms. There were some smart people a long time ago that thought about this and had the battle of the forms concept. We're going to talk about that, tell you what it is and why it happens. Look at what law governs, and then some perspectives from both the buyer's view and the seller's view, and have a little set of avoiding the gotchas. That's my presentation. And Scott is going to talk a little bit about real life type of situations where we have the creation or amendment of your purchase orders with the use of emails. So pay attention to that one. It's going to be real important. And last, we're going to have Ron, who's going to tie some of this all together for us with some real life adventures. So how does this really work? There's this concept of paper passing back and forth, and paper has gone from being real paper. Some people still use that. Other people just do everything by e. Both of them work. E does work. Faxes work. Does anybody still use a fax? Faxes work. And it starts out, one side sends the form, the other side sends a form back, and then I send you another, and really nobody is doing anything until finally somebody says, okay, here's the product. And you ship it, maybe it's used, maybe it's rejected. It's a whole set of laws that comes together that that you wouldn't normally think about. And one of the problems with not thinking this through is this set of laws is different than the common law. We'll get there. This happens, the short answer is because it does, because it always has. And when we talk about these smart people, I always like to talk to them as smart people. I view them as the little guys with the bow ties back in 1959 who started working on this collection of laws to put them together into the Uniform Commercial Code. And that has infected the whole country. So, okay, except Louisiana. It's infected the whole country, so we are using it, and you can count on it almost identically from state to state. When the bow tie boys put it together, they did it. There were some things everybody couldn't agree on, so they had alternative A and alternative B. And when the states adopted it in this particular code section and that particular code section, not for the whole thing, they had these opportunities to select A or B. But those are just the nuanced changes around the country. The rest of it, you can pretty well tell from Ohio to Indiana to California, well, maybe not California, up to Alaska, almost all the same. Why does it work like this? Because it works, and nobody really wants to change it. So how does this flow of paper go back and forth? How does it actually happen? It might start out with a request for quotation, and then you have the seller sending over a credit application to the buyer before they're going to sell to them, and then documents going back and forth, a request for proposal, all sorts of documents which each individual company is going to use until you get down to the end where a purchase order is finally shipped or is delivered. And then the product is shipped, and it's got an invoice that comes with it. It's got a shipping ticket. And you know what? All these things have different terms connected to them. And when you have all these different terms, which one is right? Which one is the one that we're going to use to determine what our contract actually was? And what's even worse about this is people are so bad at doing this that it's not that my terms are different than your terms. My terms are different than my terms. Because when I put the documents together, I wrote this one, I wrote the purchase order this day, and I wrote the quotation a year later, and I didn't look at both of them. And I said, or maybe my lawyer said, this is a good term. I just had a case like this, so we should put this in there. That's why contracts get to be this thick. Peter mentioned that I do construction law. And from a subcontractor's perspective. So I'm looking at these documents that come out, and they used to be, I talk to people all the time and say, I used to do work on a handshake. And now what do you have? You have a book that's your contract because smart guy lawyers said, oh, we have to protect you against this and have to protect you against that. Sooner or later, you've got this raft of documents that are going to help or hurt you. But what really hurts is when, particularly in the purchase order segment, they're not combined. So if you're in that process, be sure your documents at least all agree with each other. So what really are the contract terms? Your concept, your objective from the offensive standpoint, from the I want to have the best contract for me is to what? Get your terms and conditions into the contract. And the other guy? Well, he's trying to do exactly the opposite. He's trying to get his terms in and avoid your terms. We talk about this UCC, the Uniform Commercial Code again, and particularly the segment we're talking about is sales, which is in chapter 1302. Now we're going to go through all that and it's in your materials. It's the sales section. If you ever want to have this urge to go read the UCC for yourself, if you're tired at night but just not falling asleep, please go there. It'll do wonders for you. Hop on the computer, go to Google, wonderful little search engine, type in 1311, I'm not sorry, that's my other one, 1302.01. First thing it'll pop up is Law Writer. It'll take you to the raw code, and you can look right through it. It's really easy. I've also given you, or if you just want to type in, it's codes.ohio.gov, but you don't need that. If you want to get a little more in-depth research, which is probably pretty good, You can go to Wikipedia. I find Wikipedia to be a wonderful resource. Don't always count on it because people can manipulate it, but it really is pretty good for a broad overview. So we're talking about sales, and what it really is narrowed down to is the sale of goods. You know, goods are a variety of things. Almost everything you're thinking of is a good. The table you're sitting at, the chair you're sitting on is a good. My remote control is goods. The carpeting is goods. The ceiling tile. Everything that you can touch that's not real estate, for the most part, is goods. So materials and equipment. In the construction industry, I deal with it from the raw materials of carpeting, but concrete and steel and all of those things. Construction is really no different than any of your businesses because it's just a business that happens to do this particular type of stuff. If you are working with some of these contractor type people, kind of beware because there's a number of contractors who do one thing. They've got this dramatic contract that they put together for their subcontractors. And then they thought, I'm going to save time. So what I'm going to do is I'm going to use my word processor and take out the word subcontractor and put in the word supplier. Don't use those documents because there's just a whole raft of different obligations that you have as a subcontractor than you do as a supplier. Refuse to use those. You'll get yourself in way too much trouble. One of the concepts, though, when we're thinking about construction, or any of the other things where you're putting stuff together, is when is it goods and when is it services? Because the example is the supply of ready-mix concrete. You've seen the concrete trucks go down the road with the barrel turning, and they pull into the lot where they're going to drop the concrete off, back it up, and reverse the rotation on the drum, and the concrete comes out. Is that a good or a service? There's a man actually working to put the concrete, deliver it to exactly this spot or exactly that spot, to add water when he's told, to do all kinds of varieties of things, as well as just purely deliver it. Those are incidental to the sale of that good. That is a good. That is covered. When they talk to us about it in law school, like the first week in law school, the example is if you're a woman having your hair colored and something goes wrong with the color, what is it? Was that the sale of a good, the hair color, or was that the provision of a service, putting the hair color on your hair? So you have to look at which is the more important aspect. By the way, that's the service aspect. It is not the color, it is the provision of the service to apply the color. So you're looking at what is the predominant feature. In the standard, remember I said it was different, in the standard non-UCC type of area, so where it's not just this goods. The concept is contracts have to be a mirror image. Contracts, if I have one contract and you have the next contract form and they're going back and forth, you have to decide, you have to make sure that they're the same. And that can apply any number of ways. Generally, they're not ever exactly the same. And people sometimes usually sign other people's documents, but not always. Sometimes they just go to work. So, I send you a contract and say sign it and send it back and go to work, and you just go to work. In the meantime, you have sent a different contract form to me. Or, even more likely in construction, I have sent you a proposal with my terms and you have replied with a contract. And I go to work. Was it my proposal or your contract? It's the last one in the non-UCC area because I accepted your proposal by going to work. That's the way the contract is formed there if both parties didn't sign the same contract. What happens though? That's the common law. That's the last shot rule. That's not so much battle of the forms though. The last document in that sequence is the one that has the most control. The counteroffer always trumps the offer. So when you go to buy a car, you say, you see the $35,000 car and you say, I'll give you $29,000 for that. And they say, nothing doing, we'll sell it to you for 34. Well, do you get it for 34 or 29? It was the last offer. So when you're in the UCC setting, this is completely reversed. The stronger document, because there is no mirror image rule here. Why isn't there? Because the statute takes it away. The rule here is not so much that you have the opportunity to use the last document or to be stuck with only one document, but you may end up with potentially a collage of documents. However, what really happens is the UCC tries to order them to give you the strongest, when there's a conflict in terms, to give you the strongest, the distinct advantage to the first document out there. And Ron will talk a little bit about that. He's got a case right on point. If you can be the first one to talk, the first one to deliver a document, you're on top. So if you can do that, please do. It'll help you out. You can fix that along the way. If you're not the first one to deliver a document, there's ways that you can work around to make sure that your terms are in there, particularly when they're opposed to the other terms. The documents can be by way of a quote or a proposal. The response from the buyer can be a purchase order or any number of things. It doesn't have to say purchase order on the top to be a purchase order. It's a purchasing document. The UCC applies, it doesn't apply in absolutely every circumstance. First, you have to ring the bell and make it a deal that's over $500. Once that's in play, now the UCC, the rule of sales is going to apply. And in this over $500 area, the statute requires that there be a writing sufficient to indicate the contract has been made. Boy, who wrote that? I know, some guy with a bow tie. Signed by the party against whom it is going to be enforced. Same bow tie guy wrote that. And then, if you have the document that's not signed, you can't just turn around and say, he never signed my document. I don't have a contract with him. I can walk away from this. No, that can be overcome by performance. So the same concept that I mentioned in the non-UCC area, where somebody ultimately goes to work, here it's when somebody ships. Now, that will be the performance. That can still be beaten if it's rejected or any number of things, and I think Ron will touch on that also. You can object if you have this delivery of materials, but you've got a very short period of time. You can't just sit on it forever and say, okay, I don't want it anymore, and send it back. Terms can be supplemented too. And among other ways, they can be supplemented by course of dealing or trade custom. One of the trade custom ones that we learned about in law school is chicken fat. How exciting can you be? The chicken fat case that we had was somebody is buying chicken parts, and the contract says, this shall be no more than 47% chicken fat. Okay, we all understand 47% pretty easily. Well, it came through, and actually there was, who measures chicken fat? Maybe it's the pinch test, I don't know. Anyway, they looked at it, and it was well above 47. It was actually 50% chicken fat. And so that was determined by the buyer that was a breach of contract because it was greater than 47%. Aha. But there's a trade custom that says, yeah, but what we really mean in circumstances like this is plus or minus 3%. So plus or minus 3%, 50%, you still had a contract that wasn't breached by it. So judges have a way of modifying what the statute actually says by saying close enough. Doesn't always happen. Be sure that there's a history to it if you're going to make that argument. The contract really has to be in a a manner that is sufficient enough to show that you have an agreement. Now, not all the terms are going to be in there all the time. There's some things that, the essential terms have to be there. How much are you going to deliver to me? How much am I going to pay to you? But sometimes there are things that are just left out. Like, what are the warranties? Well, I don't know. What are the warranties? There's a whole variety that you might expect, but then there are a few that are implied warranties that have to be specifically disclaimed. There's the warranty of merchantability. Some call it merchantability. But I'm right, of course. There is the warranty of fitness for a particular purpose. Well, fitness for particular, what the heck is fitness for a particular purpose? It is essentially, you said to me, I want a product that'll do this. And I say, we have this X15 right here that'll just fit the bill for you. And you say, great. I have just made a warranty to you that this X15 is fit for your particular purpose. Whether I meant to say so or not, I did. My alternative, if I don't want to be tagged with that responsibility, is in my documents, I can have, in all caps, bold letters, waiver of warranty of fitness for particular purpose. And now I've overcome this concept that, that I made that warranty. But that's one of the gap fillers that the bow tie guys thought that was going to be important. People leave out warranties all the time. So let's put them back in for them, and if they want to get rid of them, they have to affirmatively remove them. Acceptance of the agreement can be made by a number of ways, by the promise to ship or the actual shipment. And this is interesting, even if it's non-conforming goods. So I tell you I'm going to ship something, I ship something, you wanted the X15, I sent the X14. I accepted the final deal that we were making by shipping even the non-conforming good. There's going to be a problem with that, but nonetheless, I have by my actions of shipping something created or finalized the contract. Sometimes there's additional terms, sometimes there's different terms. Again, we go back to the first document. So the first one says, you're going to have these warranties because I'm the buyer and I want these warranties. As the seller, I don't want to give you all those warranties. What about consequential damages? That's another one that's a big deal. So I sell you an 89-cent widget and you install that 89-cent widget in the bottom of your building. Well, the building is going to fail because of that 89-cent widget. Do you have to tear the whole thing down and replace it? If you do, who's responsible for all that work? Well, it depends. What does your contract say? Was I, as the seller, responsible for consequential damages? Or did I disclaim them and leave you only with the right to collect, to have a new one shipped to you or your purchase price refunded? That's a real common one you see all the time. So if you want to have the ability to have the seller sell you the right thing and be responsible for your resulting problems, you better be sure that they haven't disclaimed consequential damages, because bow tie guys wove that into the statute for you. Yes, it's right here too. If you want to change those terms along the way, you can make your contract add some magic words, expressly made conditional on assent to my terms. Ron's going to cover that much better than this. Where we have this acceptance, they become a part of the contract unless the offer expressly limits acceptance to the terms of the offer. They materially alter. One of the ones that you might not think is a material alteration is the inclusion or removal of an arbitration clause. Bow tie guys thought arbitration clause was a really big deal. So now we have the opportunity. I put in an arbitration clause, that's the change. So now we no longer have this, I can fill in the gaps with the rules, I have to figure out the arbitration issue. If it's not, by the way, we're talking about all these things going back and forth. If somebody ever signs a document, that's the deal. I mean, if both parties sign the document. That's going to be the deal. We're talking about the situation here where the way it really happens, I send you a request for proposal, my terms. You send back your proposal. I send an acceptance. You send your next document, your acknowledgement, and they are all different. If somebody signs one, that's the deal. If nobody signs one, remember, we revert up to preference to the first document unless you've included those magic words along the way to change it. Let's go past that. So if there's no, if the offer is conditioned, this acceptance, the non-conditional acceptance, would form the contract. And now we're going to try and include the offeror's terms and conditions. Let's look at the warranties I was talking about. I'm not going to go through each one, but if you want just the quick thumbnail to get to the types of warranties we're talking about, here's the code section. Again, type it right into Google, it'll pop right up and you can have a look. Here's the consequential damages. This talks exactly about, so you want to see it? 1302.89 takes you right to how the consequential damages work and how that is going to affect either the buyer or the seller. Now, strategic terms, the advantages that you may want to try and get. Choice of law, venue, forum, where are you going to have this case heard? Is it going to be in arbitration? Is it going to be in litigation? Is it going to be in Cleveland, Ohio, or Oshkosh, Wisconsin? Does the prevailing party get their attorney's fees paid? What are the warranties? Are you going to be in arbitration or are you going to be in litigation? And if you're dealing particularly with construction, now the Ohio legislature has imposed something that's called the Fairness in Contracting Act, which is at 1431.62. It's got a whole bunch of fun things that we've added in there that talk about choice of law, venue selection, and dispute resolution, among others. But so there's special construction-only rules. Operational terms that are important, of course, one of the most important ones, payment, performance. When is it going to get there? What are the delivery terms going to be? When does the risk of loss take place? If I am shipping from my loading dock, do I have the risk of loss ending when it leaves my dock, or does it end when it arrives at your location? I don't know. What do the documents say? Some of the legalese that people are going to look for to have in there are warranty disclaimers, consequential incidental damages, indemnification. Indemnification is a big one, and I always have a problem with this indemnification concept because for the most part, it attempts to push down responsibility for somebody else's actions onto somebody else. If it's construction, don't you like me going back to construction all the time? You know, to the carpenter, the solution is always a hammer and a nail. Anyway, in construction, there's actually a specific spot, a specific statute that says you can't indemnify somebody else for their negligent or intentional acts or omissions. Doesn't apply across the board. What about conditional payment terms? I will pay you if I get paid. That could be a very important thing if you're the seller. So who wants the particular terms? Where there's a gap, look for the gap fillers. They can include all kinds of things that you absolutely didn't intend to put in, and they can just be vitally important to you. Those gap fillers are the surprise gotchas that are just waiting for you to get stuck in the ear with them. One of the things I wanted to mention before I leave is that I do have a live program every other Wednesday, for the most part. You can tell that my math isn't exactly right here. I did one yesterday. It's a live webinar, so you log on from your computer or listen on your telephone. I always do them for free. And a variety of topics. You see my next one is getting paid on time using notices of furnishing. That's in the construction industry. These are about a 90-minute program, and if you're interested in coming to them, you've got my email here. Send me an email. I will get you on the list, and you'll get an invitation every week. All you do is click on, and you can watch it again. Oh, and you can ask questions. You can ask questions here, too. They're always ready for you anytime you want. it's there to listen. I don't have it every other week here because on the 5th of March, I'll be out of town, so I just bumped it up 1 week. But really, they are every other week, and I actually have some of my partners who will be joining me to do guest lectures in the coming months. So we're going to run the gamut of things that will be of interest to you. That's my program. Next up at bat is my partner, Scott Lewis.
Thank you, Russell. I hope I'm not going to do anything with the PowerPoint now, because I'm not using a PowerPoint. And those of you who remember the 1992 vice presidential debate, I am Admiral James Stockdale. Why am I here? I'm not a litigator. I'm the one who drafts these terms and conditions. Oh, this looks good. This will protect my client. Let's add it. We'll make it a little bit longer for the benefit of the clients. The reason I'm up here is because there have been instances involving clients of mine and others clients where the use of email, and worse yet, the instant messaging and the texting has given rise to what I've called in the article that you have in front of you the inadvertent contract. The short piece of advice is to proceed with caution whenever communicating additional terms and conditions that you'd like to propose to a standard contract. These terms and conditions used to be the fine print, and now sometimes you accept these terms when you click, when you go into a vendor's website. It comes up in so many common contexts. The real estate broker who has an addendum that he puts before the buyer and the seller, and one party says, yeah, this in an email, yes, this looks good. I'll pay you $50,000. I'll pay you $50,500, to beat the competing bidder. But I want my lawyer to look at it, and there'll be additional terms and conditions and a rider. Well, a court has said, an appellate court, a case coming out of Summit County, said no. Once you have expressed your assent, once you have told the other side, yes, these are the terms, whatever additional terms and conditions and riders you may want to suggest, that's down the road. But you have an agreement. The email itself constitutes the acceptance. And whatever your lawyer may choose to add, is going to be proposed additional terms and conditions. With just a stroke of the keyboard, the terms of a contract that you or your counsels carefully negotiated and drafted can change. There's a case, a federal case, that you'll see in the article coming out of the Southern District of Florida, where someone was being compensated based on sales leads. The original contract said maximum 200 leads per day. That's the limit to which you receive commissions. But there was a back and forth. Someone was away from his office, and when the person came back, he saw 2,000. It wasn't a typo. The sales agent said, I can sell 2,000. And the reply was, that's great. Contract. And the argument that there's a written contract saying that this is the entire agreement, any modification must be in writing, that didn't carry the day. It didn't carry the day because the communication of the offer, combined with the fact that there was a signature block indicating a writing, was enough to modify the contract. Basically, the court there overrode the entire agreement clause. A lot of lawyers and their clients sort of latch onto this, some people call it an integration clause, an entire agreement clause. No amendment is effective unless it's in writing, signed by both parties, or signed by the party against whom the obligation is being enforced. Well, there are obviously ways around that in the eyes of several courts, and this is an emerging body of law. The email itself constitutes the writing. The signature block is enough in the eyes of some of these courts to authenticate the document. That is the written instrument. I've drafted and I've looked at email disclaimers for the benefit of clients, a sample of which is before you this morning. This was for a manufacturing client, but it easily can be adapted for other types of businesses. And the email disclaimer it's a wonderful thing, but it too can be overridden by inconsistent action. If an agent, for example, has apparent authority to bind the principal, that's enough. There's a case coming out of another federal court where an insurance agent said, you don't have to put the insurance carrier on formal written notice. You've told me that's enough for you. I'll take it from there. The policy itself said you must prepare a written notice of claim. That wasn't done, and the claim itself, when the insurance company tried to deny the claim, relying on the language in the policy, the court said, no, your agent had apparent authority, and he said in an email it was okay to send it just the way you did without a formal notice to the carrier, and that was enough. The email disclaimer that we provide actually has been very helpful to a few of our clients. There's a lot of back and forth that goes on. Everything that Russell has shared with you in the past 20 minutes, that's still the set of rules that governs even the electronic communications. But courts have found it necessary to interpret them and apply them in the age of instantaneous communication, and it's created some odd results from time to time. And again, be very cautious when you receive an email that proposes to amend terms and conditions, whether it's a change order, whether it's a quote or a proposal, a contract, a proposed rider to a contract. You need to make it very, very clear that your response does not constitute acceptance. You can take it under advisement. You'll talk with your attorney. Thank you very much for the proposal. Anything that doesn't rise to the level of acceptance. And I'm sort of the sorbet. We have two main courses today. We have Russell, and I did the math. I actually am in my 30th year of practice. Sorry, Peter. But this reminded me of one of my law school classes, a refresher on UCC Article 2. And the second course is Ron Friedberg, and I'll turn the podium over to him.
Good morning, everybody. I think it's appropriate that I go last because I am a litigator, and usually kind of in the chain of command or chronology of these type of situations, the litigator becomes involved after all the things Russell has talked about and even Scott has talked about have already transpired. And kind of the question about time of the essence earlier, it sounded like the contract documents were already drafted and executed, and now you were dealing with a dispute. What's it mean, and what are the ramifications of it? I have many times been in a litigation scenario with these battles of the forms, and I'm going to just go to my last slide and tell you a real life situation. Actually, it's a case that's still pending. And so to kind of put some real parameters on some of these legal concepts we were talking about, I have a case where I actually represent the seller of goods in this case, and our price quotation basically says the terms and conditions set forth in this price quotation shall be applicable to and shall supersede any provision in the buyer's purchase order. My terms govern. My client gets a purchase order, and by the way, these documents tend to be thick and boilerplate and buried in small print, and nobody reads them. So the purchase order said, if this purchase order constitutes buyer's acceptance of an offer, such acceptance is expressly made conditional on seller's assent to the terms of this purchase order. So you have a situation where the seller says, my terms govern, the buyer says, my terms govern. Well, when the terms are totally different, which they usually are, who wins? The reason why it's been so important in my case is because there were two primary situations where the terms were different. The first was payment. My client's price quotation said, payments, when they're not received, are delinquent, they're due within 30 days, interest at a rate of 15%, or 1.5% per month, or 18% per annum is due. You don't pay me in 30 days, it's due, and I'm charging an interest of 18%. Pretty good. 18% is not a bad return, especially in today's environment. Well, the purchase order said nothing about timing of payment, but it did have what Russell alluded to before, a pay when paid clause, actually a pay if paid clause that says, I'm not going to pay you until my customer pays me. So what happens with that? Actually, in my case, the customer of the buyer, who my client didn't even know existed, didn't pay the buyer of the goods for a reason that really had nothing to do with my seller. So that's why these type of battle of the forms become so important. There was actually another provision that was really important in these battle of the forms in my case. My client's purchase or price quotation basically had a provision that said you can bring suit to enforce this provision in any court of competent jurisdiction in the state of Ohio. Kind of a broad base. And my client actually is in Lake County. We sued in Lake County. The purchase order said any dispute arising out of this transaction shall be brought exclusively in the courts of Washington County, which is Marietta, Ohio, about as far south in the state as you can get. We didn't want to go there. They actually, in the lawsuit I filed in Lake County, they tried to move that case to Marietta. And Marietta is beautiful, but it's also 3 hours each way, and that becomes expensive. So what does the case law say about this? When you have these two forms that seemingly are irreconcilable. Russell talked about how the UCC says be first, kind of a divergence from the common law, which was the last shot. Well, my client was the first provision, but you also have this purchase order that kind of does have that magic language that Russell alluded to, expressly made conditional on seller's assent to the terms of the purchase order. But the courts have held, and actually, I haven't highlighted this, but here's where the case kind of turned and said, in the beginning of the work by seller shall be deemed to constitute such assent. It was kind of a gotcha. It's like, okay, I'm only going to agree to this if you agree to my terms, not yours, and if you start the work, you've indicated your agreement to those terms. And the courts will enforce this magic language, but they want to make sure that the seller in this case is aware of it and agrees to it. So you can't just kind of do this gotcha like, okay, my terms are going to govern, if you start the work, you've agreed to it. The courts have held that there has to be, first of all, the purchase order or the second document has to say, I want to make it clear to you that I'm only going to go forward to this deal if you agree to these terms. And there has to be some express acknowledgement on that side, not just to start the work, that yes, I do agree to those terms. So yes, you can use the magic language. Yes, you can say, my terms govern, but you can't say gotcha by slipping in the beginning of the work is enough to do it. You really have to make it clear that I'm only going forward if my terms govern, and there has to be some indication on the other side that yes, I hear you and I agree to it. I want to flip back. As a litigator, one of my favorite sayings is an ounce of prevention is worth a pound of cure, because, again, I get involved at a time where the documents already exist. And since I do commercial and business litigation, almost all of my disputes involve contracts. And of those disputes, the vast majority of them, and I recognize I'm kind of doing Monday morning quarterbacking because it's easy to realize what the problem is after it exists as opposed to before. But the vast majority of the problems that I encounter from a litigation standpoint could be avoided if the parties took the time to deal with the issue in the documents. I understand, again, that there's some Monday morning quarterback aspect, but if you really sit down and focus on the problem and think it through and deal with it in the documents, you might spend a little money up front, but I can tell you this with utmost certainty: if you litigate it, it's going to cost you many times more what you will pay to consult with a lawyer to actually make sure that your rights are protected up front in the document. I've listed here just some of the things that you might want to think about in your documents to kind of even the playing field. My job as a litigator is to, when I'm representing a plaintiff, it's to make them as whole or as close to whole as possible. And a lot of times, because of the way the documents are written, that's impossible. Because, especially let's just say you have a purchase order, you have a sale of goods for $25,000 you haven't been paid. So you come to me and you say, I want you to sue that SOB and collect my $25,000. Well, from the time you've hired me and you're incurring my time and expense of going after that $25,000, it's really going to be hard for you to be made whole, because even if I collect the $25,000 relatively quickly, you're going to pay for my time. So even if I do a brilliant job and do it quickly, you're still going to get less than $25,000. Here's some of the things from the plaintiff side that you can include to at least increase your chances of being made whole. You can have interest on late payments. Now, one thing that a lot of people do and think it's enforceable, they'll never have any interest provision in their purchase orders and in actually the documents, but they'll send an invoice that says a rate of 1.5% will be charged per month on past due balances. If you don't have some documents that signify some agreement for the buyer to pay interest, the fact that you slap that on your invoice doesn't mean that it's enforceable. In fact, it's not, because they never agreed to it. So one of the things you might want to do, if you're a seller and you say, look, if they don't pay, I at least want to get some interest, which will increase my chances of being made whole and might absorb some of the legal expense I'm going to incur, is to put a provision for interest that if you're late, you're going to pay that whatever percent per month or per year. If it's in the document, it's enforceable. Now, Ohio has what's called a statutory prejudgment interest rule. So that problem is alleviated to some extent, and case law says that if you have a contract, you are entitled to prejudgment interest as a matter of law from the date the claim accrued until you get paid. It used to be that the Ohio prejudgment interest rate was a flat 10%, which again was a pretty good rate of return. So, if it took you 2 years of litigation to get paid, well, at least you're earning 10% on that money, and that's going to help diffuse some of your legal fees. But I believe in 2002 that changed, where the 10% wasn't a flat fee. It's now tied to a short-term treasury rate. I think the Ohio Department of Taxation every October comes out with what the rate is, and I believe in 2014 it's 3%. So if you want to have some meaningful interest rate where there really is some stigma, some stick for late payments, put it in your document. Attorney fee provisions. Um, Many of you might have heard what's called the American rule, and that is, in America, each side pays their own attorney's fees. I can't tell you how many times somebody comes to me and says, well, I just don't want my damages, I want them to pay my attorney's fees. And I'm saying, that's not the way it works. Now, there's some statutory exceptions for like employment discrimination and something, but generally in commercial business litigation, each side pays their own lawyer, unless you put an attorney fee provision in your document that says the prevailing party shall pay an attorney fee. Those are enforceable. Courts will look at them for reasonableness, but they're generally enforceable. So again, if you want to be made whole in that $25,000 example that I gave you, put an interest provision in and put an attorney fee provision. And so the chances are that you get your $25,000, you're not taking big chunks of that out to cover the cost of going after it. Forum selection clauses. I gave you that example in my case where one said Washington County. Courts will generally enforce forum selection clauses as long as there's a reasonable basis for including them. So you want to have the home game. If I imagine most people here in Northeast Ohio, you want your disputes litigated in Northeast Ohio. You won't have to go somewhere else in the state or somewhere else in the country. And generally, courts will enforce those. Jury trial waivers. I can tell you that I've done a number of jury trials. They are longer, they are way more expensive, and especially in commercial disputes, oftentimes they're not the best mechanism for resolving disputes. So again, people have a constitutional right to a jury in this country. However, by contract, and you have to make it conspicuous and it has to be clear, but you can waive juries and have a judge decide the dispute. And actually, in Cuyahoga County, we have a commercial docket where you have a select few judges that are well-schooled in commercial disputes. So a lot of times you get a better deal having a judge decide your dispute, one of these commercial judges, than a jury of your peers. Kind of scary what that might look like. Mediation and arbitration clauses. I'm a big fan of alternative dispute resolution, especially since with all of the paper that Russell talked about and all of the, especially with e-discovery, and people are sending emails and texts and voicemails and the cost, a lot of times taking it out of the judicial system and putting it in mediation, which is kind of mediation is not binding. The nice thing about it is no one can enforce a result on you that you don't agree to. And arbitration, which is more a private adjudication. Again, you can't force somebody to mediate, you can't force someone to arbitrate, but if there's a mediation and arbitration provision in your documents, courts will enforce them. Again, from a seller's side, again, you may want personal guarantees or security interests to protect the collectability of the debt. And Russell talked a little bit about disclaimer of warranties, limitation of damages, and limitation of remedies and exclusion of damages. Again, those are enforceable, especially in a commercial context where there is equal bargaining power, you have sophisticated entities. So you can, yeah, we talked about the power washing example, but in a general, more commercial context, if you say, I'm not going to be liable for lost profits, consequential damages, I'm not going to be liable for anything other than repair or replacement of the product I sell you, generally, those provisions are enforceable. So, again, I know it might be taking business away from me, but I urge people who are involved in the purchase and sale of goods to have your lawyers, which are hopefully us, look at the contracts and spend money on that ounce of prevention to avoid the pounded cure at the end.